So, good morning. My name is Shazia Khan, and the unit that we'll be doing today is business law, and the unit code is H6170736. The credit value is 15, and the unit level is 4. So, we'll be doing this unit today, and the whole point of this unit is to understand how business law is applied to any sort of business when a business is run, and how you will gain knowledge of understanding how the law operates in the UK in regards to any sort of impact of the law on the UK economy and business decisions. We'll be looking at legal solutions, and the experience gained in the unit will be trying to understand and illustrate the impact of law on normal business operations when registering businesses, and also looking at elements of market abuse and direct responsibility, and how you will be able to apply employment law in regards to it. So the learning outcomes for this unit is there's 4 learning outcomes and then an assignment discussion session. So the first learning outcome is to explain the nature of the legal system, which we'll be doing today. We've got the illustrating the potential impact of the law on a business. And then we've got learning outcome 3, which is to examine the formation of different types of business organizations. And learning outcome 4 is to recommend appropriate legal solutions to resolve areas of dispute. So each one, we're going to go through the essential legal system, which is looking at the first one, which is learning outcome through, which I'll go, learning outcome 1, which I'll go through in a bit with you, okay? So we're going to go through each one and examine each one individually, so you've got a little bit of an idea. And this is the learning outcomes and assessment criteria on how you would get a pass, merit, or distinction when it comes to completing this assignment. So you will look at elements of each one. So you need to identify which element would get you a pass, merit, or distinction. And we'll go through this more in the assignment discussion session. Recommended resources for you are things like textbooks, which are listed there. Adams, Business Law for Students, Elliott, English Legal System, and websites there that you can use, and links there that will help you identify and do the assignment, or if you want to do any additional reading. Okay, so have you got any questions around the module specification? So what I'm going to, Keith, have you got any questions or anything?
No, I'm good.
So what I want to show you is quickly what the assignment brief looks like. The assignment brief is something that we have to go through. There's 2 parts to this assignment. So the first one is here, which is part 1, which looks at the element of, this is how it looks, and this is how it's on Moodle as well. So you will have a better idea of how it looks. Can you see that? Yeah?
Yes, I can.
Okay. So this is assignment 1 of 2, where you will look at the introduction, general information, the submission, the Harvard referencing, and then it goes on to tasks, what is expected of you in this assignment. I'm not going to go through that now with you because we've got an assignment discussion session towards the end, okay? I just want to show you how it looks, so if you have to look at it on Moodle, it's there for you, okay? The next one is the second bit of the assignment, which is part 1 of 2, I think. This is 1 of 2. Let me just get the 2 of 2. So let's just. So part 2. So let me just share part 2 with you. Right, okay. So. Hello, can you hear me? Hello?
Yes, I can.
Yeah, excellent, Keith. Thank you. So this is part 2. Let's just open up, see if I can get part 2 up. So can you see this? This is part 2, and this is how it looks on Moodle for you if you need to get it. And this is looking at another bit of the assignment. So there's 2 assignments, and this is this part 2. So it looks at the general stuff, then it goes to the learning outcomes and what is expected of you in the tasks. So this is what we'll go through when it comes to it. And for part 2, you have case studies that you need to do. So there's four case studies, three case studies you need to look at, and you need to file a report. So you look at that, and this is in the final session when we do the assignment discussion. I just want to show you them so they're available for you on Moodle and what they look like, okay? So now going on
Okay.
to the final thing now is looking at the element of what are we expecting in learning outcome 1. Okay, so let me just share learning outcome 1 with you. So we've got learning outcome 1 there, which is looking at elements of business law. Can you see that? Have I shared that with you?
Yes, I can see.
Excellent. So learning outcome 1 is an introduction to the law, really, to explain the nature of the UK legal system. So when we look at the indicative content for learning outcome 1 is looking at defining a legal system, the purpose of law, the evolution of law, and different sources of law. So we look at legislation, directives, case law, and treaties. We look at divisions of the courts, its structures. We also look at the difference between civil and criminal law and the justice system and the role in government in lawmaking, the justice system, and the organisation of the judiciary. So, firstly, what is the legal system? So, the legal system in the UK is a set of rules and institutions and procedures that govern any sort of disputes on how the law is enforced in the UK. You know, society play a big part in this, and we have to implement the law and any sort of rules for us to follow. You know, the legal system is there to make sure everyone is protected and the laws are enforced. So, for example, the laws are introduced to prevent you from talking on your mobile phone whilst driving, and they issue penalties for that, like 6 points and a fine. And the reason is they want to protect everyone on the road. So, you know, these laws are put into place to protect individuals and make sure that people follow them. Are they always followed, Keith?
Not necessarily.
No, not necessarily. Not all the laws are always followed. Some people don't believe that, you know, laws are in place to protect people, but the whole point of it is they are passed according to how they protect an individual. So the purpose of law. So we have the UK law, and then we have the purpose. So the whole point of it is to make sure that it, you know, it reduces any sort of conduct or behaviour of the society and provides an acceptable kind of behaviour. So it's there to create general rules, setting standards for conduct, protecting fundamental rights and establishing procedures for disputes. You know, so if there's a dispute against someone, you can go to court, you know, and identify any sort of dispute. It's there to provide social order, maintaining the social order between individuals and make sure that they, you know, follow what is required to prevent any sort of, you know, riots or any chaos or anything like that. So, you know, in courts, law is there to prevent any sort of disputes and resolve them. What kind of disputes do you think can go to court?
Legal agreements.
Yeah. Do you think employment law disputes can go to court as well?
Yes, it can.
Yeah. And what kind of employment law disputes can there be?
Uh, not paying salary on time.
Yes. Not paying salary on time, not paying enough salary, not going by the minimum wage, you know, discriminating against someone who may be having a disability or discriminating someone on age. These are conducts in regards to employment law that, you know, in the businesses must follow. You know, the whole point of law is to define what is acceptable behavior and what is not. And you know, the state is there to implement this so it protects everyone in regards to this, so that nobody, you know, has any sort of complex matters that they need to go through. You know, there are mechanisms in place for this. So, as we said, law is a body of rules that define, how to control things and make sure that they are binded on and that they are obeyed. And if they are not obeyed, sanctions are put in place. And sanctions, what kind of sanctions do you think can be put in place? What
Mm,
what kind of sanctions do you think can be put in place? What is a
Uh,
sanction?
sorry?
What is a sanction that can be put in place? Could you get fined?
Yes, you
Yeah,
can get
you
fined.
can get fined, you can get prisoned, can't you, as well? If you do something wrong, you could go to prison for that.
True.
Yeah, so sanctions are put in place. So we look at the purpose of law. According to ENL legal, the laws are there to ensure that victims of crime receive the right penalty, for what they do. And the evolution of law began a long, long time ago when it was uh, customary rules were put in place in early societies to develop a more formal written codes and complex legal systems. They shift, it was set back to Anglo-Saxons to 1925, where there were feudal courts in place. And the whole point was that they gradually absorbed and gave more powers to different types of courts. And they began as unwritten constitutions, customs, or down from tribes that dealt with them. So at that time, there were tribes that dealt with them, and people relied on the customary laws to make sure everything was okay. The whole point of it, they were divided by common law, and because the common law was not enough, then equity was developed by the Court of Chancery, and the reason equity was developed was to ensure that there were more remedies in place. So common law was good to use, but it didn't have all the remedies that were available for individuals. So then equity came about to make sure that there were more remedies available. Then by the 17th and 18th century, common law absorbed the law of merchant. And then during the 19th century, was the punishable by death was greatly reduced. So a lot of the laws were reduced according to modern evolution and how things changed. The whole point of it was um, the the law continues to evolve, change all the time because of there's a change of society. Things are being changed, things are being created, and new laws are being created. So it was to be changed. So the whole point of it was it changed society. So the influence of new technology, it plays a big role in changing society. Why do you think technology has a big influence on changing society in regard to laws? What do you have
Uh,
we have now?
it's
Sorry, what was that, Keith?
what? Sorry.
Why do you think technological changes have an influence on the new legal frameworks in society?
Uh, it has made everything seems easier and even going ahead and taking other people's jobs.
Yes, it makes it a lot easier, but is there more technological crimes that are happening,
Yeah,
like
then yes.
cybercrime and things like that?
Yes.
Yeah, there's a lot of crime that's happening online, like data privacy, cyber law. So, the digital age, now presents kind of new challenges. Historically, it wouldn't have, but now it does present new challenges. And the reason is, that technology has taken over. There's a lot of cyber crime, there's a lot of intellectual property crime, data crime. GDPR, people's data is going missing. So that impacts on everything, and society changes, so laws will change as well. And also the next one is sources of law, and these are different sources that shaped the legal landscape itself. So there's different sources of law. And the sources of law in the UK are things like legislation, common law, and EU law, which we are out of Brexit, but it's supplemented into other sources of UK law, like conventions and authoritative works. So, these are sources that include acts of parliament and delegated legislation, while, there's common law in play, there's conventions and, rules and sources in place. Legislation is a big part of it. So we look at the two types of sources of law, and their first one is primary sources of law, which includes things like legislation, which are acts of parliament. It could be retained EU law from the EU, uh, prerogative orders, and it could be Church of England measures, so legislation passed by the General Synod. And then we've got another one, a part of primary sources of law are case law. And why do you think case law is so important? When it comes to
uh,
case law, why do you think it is so important to have case law?
to maintain integrity into the business.
Yeah, but when we have case law, if there's a case going through the courts now, which is similar to a past case, do the courts take that into consideration?
Yes.
Yes. They will look at the facts of that case. They will look at how that case helps this case, and they will take into account past cases when they're making decisions. So case law is really important. Decisions of any higher courts, which are binding on lesser courts. Then we have secondary sources of law, which are things like, legal encyclopedias. It could be law review articles, legal experts, decisions of courts or other jurisdiction. It could be legal dictionaries. It could be American law reports. It could be, encyclopedias, legal dictionaries, and these are things for gaining any sort of overview of the legal topic. And the whole point of secondary sources is to understand the topic, to make it explain in more detail. And secondary sources are full of citations, and they also secondary sources are also there to provide expert commentary and analysis that can help you understand any sort of errors or points of law that you don't understand. So we have divisions of the legal system. In the UK, we have divisions. There's 5 levels. We have the Supreme Court, the Court of Appeal, High Court, Crown Court, and County Court. Under the High Court is the Magistrates Court, and these are very similar to the ones in Northern Ireland. And these are the divisions, and they are made up by the jurisdiction, and they specialize in certain areas. So these specialize in the different areas that deal with different specialist kind of areas of law. Then we have the court structure here. So the court structure, we have at the top the highest court, which is the Supreme Court, which is the final court of appeal of all UK civil cases and criminal cases from England, Wales, and Northern Ireland. Then we have the Court of Appeal. They hear the High Court, Crown Court, and certain lower courts. They have a criminal division and a civil division. We have then the High Court underneath that, which have deals with complex cases, and its civil claims as court of first instance. It's divided into 3 divisions. We have the Queen's Bench division, the Chancery division, and the Family division within the High Court. Below the High Court, we have the Crown Court, which deals with more serious criminal cases and can hear appeals from magistrates' courts on sentencing. Under that, we have the Magistrates' Court, which handles the majority of criminal cases, If they are more serious, then they're sent to the Crown Court. They also deal with some civil matters. On the other side, we have the county courts who deal with the more civil disputes, including debt, contract, disagreements, and things like personal injury claims. And then we have below them tribunals. Now, tribunals are really important because you have tribunals that are for specialized areas of law. What kind of tribunals can we have? Do you know? Why do we need tribunals for special areas of law? So you have things like
Uh,
employment, you have things like family, you have things like immigration. They have specialist areas of law that deal with tribunals. And the reason is that they have this specialist knowledge and they're able to identify these cases through that. So, for example, immigration law, if you've got a refugee case or if you've got an immigration case, spouse visa case, maybe that hasn't gone through, that won't go through their courts, will need a specialist tribunal. So, tribunals are specialist areas and they handle specifically the specialist areas. So now we're going to go on to looking at the difference between civil and criminal law. What do you think the difference is before we go into it between criminal and civil law? What do you think the difference is, Keith?
I think a civil war is maybe a disagreement between one another,
Yes, excellent. Yeah.
and a criminal
What do you
law
think
is,
criminal is?
for example, if you steal from your friend's shop,
Yeah.
that's a criminal law.
What about criminal is?
Sorry?
What do you think criminal is? Did you say
Criminal
when you steal
is,
something from a shop?
yeah, when you commit an
Yeah,
offense.
yeah. You commit an offence. And one of the citations in one of the books called
Yeah.
Introduction to Law was where William Gildat said that the difference between civil law and criminal law turns on the difference between two different objects which law seeks to pursue, redress or punishment, meaning, in other words, that criminal law is to punish for an offence and civil law is to provide a remedy. For example, for the injured party, a personal injury claim, it could be a remedy of maybe compensation. So civil law is a remedy, criminal law is an offence, criminal offence. Okay, so let's look at each one in a little bit more detail. So civil law is where the element of, like you said, is disputes between individuals, organizations, or the state. Like things like in a business contract disagreements, it could be personal injury claims, and it differs from criminal law because there's no form of punishment, and they are normally, these are against individuals, but they are normally heard at county court or high court. And so they do this through mediation. What does mediation mean?
I don't
What
know.
is mediation? Sorry, what was that, Keith? What is mediation?
I don't know. I don't know what's mediation.
Mediation. So what they do, mediation is where they get people together from the same organization who has the disputes and try to mediate it outside of court. Okay,
Okay.
so without going to court, they come up with a resolution before they go to court. So it's like a negotiation,
Okay.
mediation. And this is, where they would try to mediate something. So if there's any form of compensation, anything like that, then they try to get a resolution. Examples of civil cases, take cases maybe road traffic, personal injury, medical malpractice, workplace accidents. It could be slips and trips. It could be divorce. Child custody could be part of civil cases, breach of a contract, unpaid debts. If there's any unpaid debts, it could be unfair dismissal. It could be, it could be elements of property disputes, but that is all civil law. So civil law cases often hinge where an accused person legally has a duty of care towards the claimant. It's like, for example, a solicitor has a duty of care towards their employee. If the employee is injured, the employee can prove that, then that is a breach of duty of care. A doctor, another example, could have a duty of care to his patients, that he needs to obviously not do anything that would breach that. So, this is where they have a duty of care. Then we have criminal law, and this is a body of law that defines crimes and established punishment for any sort of harm to that individual or any sort of breach of criminal law. So, it could be anything. And the ones that are prosecuting you when it comes to criminal law is the CPS, the Crown Prosecution Service, and they will be the ones that prosecute you in line with that. Examples of criminal law. Can you give me some examples of criminal law? What do you think the
Uh,
examples of criminal law could be?
Robbery with violence,
Yeah, yeah.
hit and
It
run
could be,
chase.
yeah, sexual offences. It could be theft. It could be petty theft. It could be burglary, arson. It could be money laundering, drug dealing, driving without under the influence, dangerous driving, having a possession of a weapon. These are, if you're convicted, you receive a penalty or a sentence. You maybe a custodial sentence, it may be community orders. Um, and, if you're found guilty, that you could be go to prison in regards to it. At the moment, there are cases going through in the Crown Court, but it's very, very limited because at the moment the courts are very full, and the courts are full, but also the prisons are 95% full in the UK. So, it's very hard to put people in for petty offences like maybe pinching a bar of chocolate, or maybe like fighting with someone. It's very, very hard at the moment because the courts are full, and also the prisons are full at the moment. So the justice system in the UK, so it has three branches, the justice system. Um, and the three branches that we have, which are in regards to Parliament, the state, are the two branches of are the executive or the government and the legislature. And we also have the judiciary, which is the one that deals with the element of the laws in regards to it. So it has the UK government is structured with an executive, a legislature, and judiciary, and they are not completely separate. The executive is the one that is government led by the Prime Minister and Cabinet and creates and implements policy. The legislature is Parliament consisting of the Crown, the House of Commons, and the House of Lords. And then the judiciary is courts led by the Supreme Court, who interpret the laws and ensure that they are followed. So, these are the three main ones. The executive's role is, like we said, to formulate and implement government policy and laws, and that includes the Prime Minister, the Crown, and the Cabinet. We have the legislature who passes they make and pass the laws, and that's the Crown, the House of Commons, and the House of Lords. And then we have the judiciary who interpret the laws and ensure they are applied. So this is judges and in courts and tribunals, with Supreme Court as the highest court. And they work together, they're closely linked, but they are not separate to each other. They work together to ensure that society plays a big part of it, and there are checks and balances in place, because sometimes there can be the element of abuse of power between the branches. So the role of government in the UK, so the government's role in lawmaking is to propose any sort of propose, draft, and pass laws through legislature, while its role in the justice system is to ensure that laws are enforced and impartially and fair. It's really important that you are passing laws that are fair, um, and then you have, they are the executive is the one that drafts the new laws, and often begins with things like this element of a green paper or white paper. And the proposed laws are called bills. These are called bills, and they are approved by the House of Commons and House of Lords, and then given royal assent by the King, which is the monarch. And the reason is it has to go through the monarch to get royal assent, and then from a bill, it becomes an act of parliament. And once it's passed, the relevant government department is responsible for putting that new law into place. So, these it goes through a rigorous procedure to become an act of parliament. Do you think there's a need to go through this long procedure of first reading, second reading? Do you think do you think there's a need for it, Keith?
Uh,
Do you
yes
think,
and no.
yeah, do you think when passing a law, we have to go through this rigorous process?
It's yeah, to maintain order, you have to go through it.
Yes. To maintain order and make sure that everyone agrees to the act being passed, you know,
Yes.
and all the time there are checks and balances in place to make sure that each body is prevented from becoming too powerful, and making sure that they are following the laws in place. Then we have got the organization of the judiciary, and the organization of the judiciary is in regards to the element of the Constitutional Reform Act, and that act was a UK act in 2005 that reformed the judiciary and promoted a separation of powers. And it created this is when the Supreme Court was created in the UK, which is the highest court from the House of Lords. And this act reformed the role of the Lord Chancellor, and established the new Judicial Appointment Commission to create an independent process for appointing judges. So it was quite important, this act. And I've got a video here that is in regards to the Supreme Court in 2005 when it became the Supreme Court. I'm just going to put that on for you, okay? So just give me a minute. You might not be able to see that. Can you see this or no?
Yes, I
No,
can see.
you can see can you hear it?
No.
Okay, so maybe I need to share this again. Let's go back to that. Right, and stop sharing. Share the video window. That's it there. And there's that one there. And I'm sure you can the share audio, share a tab. Right, okay, so I've done that. Can you hear this? Can you hear it?
No, no. There's no sound.
You can't hear it.
Yes.
You can hear it. Yeah,
No, I can't.
you
There's no
can't.
sound.
It's why is there no sound? Let's have a look. There should be sound here. What's there no sound? Um right, okay, so let's see if you can hear it now. It says share sound. Can you hear it now, Keith?
No.
This is annoying because you should be able to. Let me just see if I can right click this, copy this, and see if I can. You should be able to hear the sound, but I don't know. Right, okay, so allow. Um, right. So let's go back to it now. So let's see if we can stop sharing. See if we can share a link now. What's going on? We'll go back to that. Share the link. don't think you'll be able to hear it. I don't know what's going on here. So this video is just I'll just give you a little bit of an overview. You can watch it in your own time, Keith, okay? And this video is regarding the element of how the court system works in the UK, and how the element of the UK Constitution and what the role is of the judiciary in regards to this. So it was really important in regards to the judiciary's role, in regards to identifying elements of, the judiciary in regards to how they work. So the role of the House of Lords was abolished in 2005. Sorry, the key changes was that they created the Supreme Court, and one of the elements of that was the House of Lords, which was created by um, the constitutional law, and that was in regards to identifying areas where the UK Constitution needed to be changed. And they brought this Supreme Court in, and it's one of the highest courts that deal with any elements of that. And the reason behind why they brought it in was they needed change. Hello, can you hear me?
Yeah, I can hear
Hello?
you.
Yeah, so there was a need for change, so that's why they bought it in. And there's only one lady that deals is part of it, and she's called Lady Hale, and that's the video that you need to watch where she explains the role of the judiciary and why it was brought about, and why the House of Lords created a new independent Supreme Court to hear all appeals from England and Wales. So the creation of the Supreme Court is separate, is physically separate from Parliament, but they work together and they act as a judicial independence. So they're independent, and they that is the only independent, which was the only legal principle in 900 years. It also the constitutional reform Act 2005 also reformed the office of the Lord Chancellor, and was historically both a minister and the head of judiciary. And the judicial functions actually transferred to the Lord Chief Justice, and the role was defined on a more of an administrative and governmental duties. They also had judicial appointments, where an independent judicial appointment commission was created to over the role of selected candidates for judicial appointment. They haven't got, I will be honest with you, they haven't got many women within the Supreme Court. At the moment, there's only two women, more men. And that's one of the criticisms, and also more individuals needed from ethnic minority backgrounds is one of the things. So that video explains everything. So have a look in your own time at that video, because it's quite interesting about the position of the Supreme Court. So we've finished learning outcome one now. These are the references there. So in regards to learning outcome one, we looked at the element of what the law, I'll just give you a summary of what we've done. So what is a learning outcome one? We looked at explaining the nature of the legal system. We looked at what is the legal system in the UK and what are the different types of legal system. We then went on to look at the purpose of law in regards to, identifying and providing a framework for protecting individuals. We looked at the evolution of law. We also went on to look at the different sources of UK law. We looked at primary and secondary sources. We went on to look at the division of the legal system. So, by legal tradition, we have civil law, common law, and we have also religious law as well, and customary laws. We looked at the hierarchy of the courts: Supreme Court, Court of Appeal, High Court, Crown Court, County Court, and Magistrates Court. We then went on to look at the difference between civil and criminal law, what civil law is, and use some examples of each one. So civil law was things like, medical malpractice, where the doctor does something which affects a patient. Workplace accidents, it could be slips, trips, and falls, and things with road traffic accidents and unfair discrimination. We then went on to look at criminal law, And examples of criminal law, things like murder, manslaughter. It could be things like assault, kidnapping, domestic abuse, sexual offences, driving under the influence, and a possession of any sort of offensive weapons or trespassing. Some of the elements, if there's any sort of criminal damage, would apply to criminal law. We then went on to look at the element of the UK government system, and we looked at the how the government is structured. So it has an executive, a judiciary, and a legislative, and they're not completely separate. They work together, and each one does something different to make sure that there's no abuse of power, or one saying I'm more powerful than you. We then went on to look at the role of government in lawmaking, so things like policy and drafting, proposing laws called bills, and then they become an act of parliament, enacting them by both houses, House of Commons, House of Lords. We also looked at the role of the justice system, things like judicial independence, ensuring that there's a fair system. Why is it important to, ensure that the UK justice system is impartial? Keith, why do you think it's
Uh,
important, to
to
be fair, to
yeah,
maintain this fair system? Why do you think it's so important?
uh, it also can help run the economy better.
Yeah, yeah. Also, we need to, as a justice system, we need to operate impartiality and, make sure that, we are ensuring this fair system and everyone gets a fair hearing. In the UK, it's so important. We then went on to look at the organisation of the judiciary, where there's got a hierarchy of courts from different offences down to elements of how the justice key aspects of the judiciary being impartial and independent, constitutional role, and separate jurisdiction. We finally went on to look at the Constitutional Reform Act 2005 and what that did in regards to making changes, reforming the judiciary and promoting a separation of powers. And we looked at key changes such as the Supreme Court, how it is one of the highest court now. And we looked at the key provisions, things like judicial independence, the Lord Chancellor's position, how it changed, and judicial appointment and the rule of law. So we looked at elements of the UK Constitution, the historical background, and how the UK, constitutional legal system works in the UK. So these are the links here for the references that you could use. If there's any sort of, have you got any questions before we finish the
No
session?
questions for now. No questions
Sorry?
for now. No questions for
So,
now.
oh, okay. So what we're going to do, you've got another session tomorrow with me for
Okay.
the element of learning outcome 2. If you don't have any questions, thank you for attending today's session, and I will see you in tomorrow's session at 9 o'clock.
Okay. Okay.
Thank you, Keith. Thanks a lot.
Okay.
Have a
Thank you.
good
Bye.
day. Bye.